Okay, we are back for the last section of Unit 3. So the last part of civil rights. So we'll talk about some newer groups that things have changed for more recently than the 60s. And then we'll get to our last topic of affirmative action, which there'll be a couple of court cases. One is really important. It's not part of our 15, but it's important to understand the way affirmative action sets these days. So newer groups, the graying of America. In class, I would go, so who are we talking about here? We're talking about, of course, I said old people. And yeah, that includes me, right? But we are getting older as a society. If you remember your population pyramids, if you're an AP human, the top part's getting larger because we are living longer. And there's more of us too, right? The baby boom generation is retiring and all of that. So sometimes it's called the gray liberation movement, a play on something happened a little bit earlier called the gay liberation movement. But there are things that happen there. We're going to talk about gays and lesbians shortly because they're part of this as newer groups as well. So in 1975, things started to change. No federal funds for any organization discriminating against 40 plus because of age. So that was put out there. So that law is out there. No general compulsory retirement age. It used to be. I mean, it was generally referred to. That's why we still kind of look at 65 as the retirement age, because it used to be the mandatory retirement age. And whatever you were doing, you were working for a regular old company here, corporation there, whatever. When 65 came along, it was retirement time, and you had to go. So those are no longer out there for a general compulsory retirement age. However, um, there can be mandatory retirement ages for some professions. So think about airline pilots. There is a mandatory retirement age for them. I think it's like 60 or something like that. Commercial airline pilots we're talking about, and there's reasons for that. Your reactions slow down as you get older. It's like the rest of your body sort of slows down when you get older. And nobody wants an airline pilot up there flying a plane load of people whose reactions are not as quick as they used to be. Same thing for me. I mean, I'm 57, and about 5 years ago I stopped riding a motorcycle, mostly because my reactions were slower, and I didn't feel safe anymore riding a motorcycle because of those ideas. Because you do get just a touch slower. All right, so disabled people, another group, and they've been protected from discrimination since about 1973. We talked about the law that affects this now, so hopefully you remember it. We talked about it back in the federalism part of Unit 1. But this idea includes inaccessible environments as a form of discrimination. If handicapped people, and we were usually thinking at that time, because I remember this, a handicapped person was a person in a wheelchair, and so that's when these laws started to come about. If your building is inaccessible to a person in a wheelchair at that time, and certainly now, that became a form of discrimination. And now, of course, we've expanded that to blind people and deaf people and a variety of others as well. So we get those things like braille and wheelchair ramps and public restrooms and things like that. So those things, those are out there. In 1990, and this is when we talked about the Americans with Disabilities Act that created, if you remember, we're talking about in federalism, we talked about unfunded mandates, and that's where this kind of came from. But the idea of what it did was, of course, it must make what we call reasonable accommodations for those that are handicapped. You go into public areas that have public restrooms. There's usually at least one that's handicap or wheelchair accessible and stuff like that. We have parking places, right? Handicap parking places, that kind of thing. So what's the controversy today? The controversy today is what actually constitutes a disability. It's not, somebody in a wheelchair or what have you, or somebody missing a limb, things like that. Of course, those are considered disabilities. It's things like AIDS. Is that a disability? Certain, not total eyesight loss or total hearing loss, are those disabilities? Is obeseness a disability? There is a group out there, a interest group out there that's trying to make obesity a disability. Is depression, clinical depression, a disability? Stuff like that. That's where we're kind of sitting today with what constitutes disability. All right. So gays and lesbians, a sea change. That means a massive, major change since 2010. So maybe just halfway through your lifetime or so, maybe a little less, right? There's been a massive change. So something you might not even realize that there's been a massive change because you've been paying attention basically to the world since you've been about 10 or so, and that's after some of these major changes happened. So, for instance, no longer barred from military service, marriage extended to all states. We talked a little bit about that. We talked about full faith and credit if you remember, and it's Article 4 of the Constitution. That's what ended up with the Supreme Court saying that yes, if somebody is married, a gay person, a gay couple is married in one state, then they are married in your state. Even if you don't have that, they have to be considered that. What's on the horizon, or what's happening right now, right? Gender identity. What does it mean? How is it, or is it discrimination to do this, that, or the other thing? Major issue today that's going to be in the courts. A variety of things are going to come up for a very long time. Okay, the last subject then, I think there's 3 slides on this, and then we're done, is affirmative action. We need to define it first. Policy designed to give special attention to or compensatory treatment of members of some previously disadvantaged group. And generally, when we're talking about we're talking about minorities, and we're generally talking about the Black population, which is where this began. It was a move beyond, remember, the idea of equal opportunity to maybe more towards equal results. And the most controversial part are what are called quotas. Quotas are set-asides. They are things that say we have X many slots, and we're going to set aside this many slots specifically for a previously disadvantaged minority. That's called a quota. And they do, there's no doubt about it, no matter what side you're on, they clearly discriminate against a previously disadvantaged group, or in favor of a previously disadvantaged group. Now, it's what is that allowed or is it not allowed is where we're at. And if you remember, when we talk about those 3 levels of scrutiny, this is at the top, inherently unconstitutional, unless it creates, or unless it's as a result of and the words in the law are a compelling government interest. So that's where these cases come from. So what happened was the federal government mandated all local and state governments, plus institutions receiving aid or contracting with the government, to adopt affirmative action programs, and that's where court cases came from. And the most important one is talking about how far is too far. And that is this case here. So it's not one of our 15, but you have to know what it's about. And it's about affirmative action. So, and it's called the Regions of California versus Bakke. His name's Alan Bakke in 1978. And we usually just call it the Bakke case. And it stemmed from the University of California, Davis. Their medical school had 100 slots, and they set aside 16 in their med school for disadvantaged groups. Okay, so that's a quota. These 16 will be filled by these people, these types of people only. And so Mr. Bakke and then his lawyer, so he was rejected twice, and so he and his lawyers did some research, and they found out that the mean MCAT score, the medical aptitude test, for those admitted under that program in those 16 slots, those set-asides, were much lower than his. So he sued. He said he was denied equal protection. He was discriminated based on his race. So he sued, and the Supreme Court agreed. He was discriminated based on his race. So the idea here is the ruling says a university can use race or ethnicity as one element, but not the element. And that's sort of where we are at today. And it also said, basically, there are no quotas allowed. And that was a specific quota. Okay? You can't use race as the only element. And that's where we have all the controversy today is what does this really mean? What can you do and what can't you do? So we have 2 other cases. They're both from Michigan. They both were argued at the same time in the Supreme Court. The first one is the University of Michigan's Graduate School of Law. Okay? So their law school, the Supreme Court said, yes, your affirmative action program is legal. They could use race as what they called a plus factor when considering admission. It was narrowly tailored, and this is the guy coming out of the court. It was individualistic, so it wasn't just this big quota, this will be it, and that's that. It was also called holistic and not mechanical. Again, it was not a quota. But the other case that they heard at the same time, also involving the University of Michigan, that's why they did them together. That's why you have the same person as the defendant. That's the Attorney General of Michigan at the time. The Gratz versus Bollinger case, the University of Michigan's undergraduate admissions program went too far. Theirs was determined to be unconstitutional. So their law school was fine. Their undergrad was not, because they automatically awarded 20 points out of 100 points needed for any member of a racial or ethnic minority group. Now you go, okay, 20 points, that's 1/5. Okay, whatever. Here's why it went too far. It became unconstitutional. That 20 points was more points than you got for academic excellence or writing ability or leadership. Those things that colleges are supposed to look for. So what they said was that went too far. So that's kind of where we're at, is how far is too far in tailoring some of your programs for trying to do some sort of affirmative action of some kind or other. So that's where we sit. We are ended. We are done with Unit 3. And remember, we've got a quiz coming up this week and then a test coming up at the end of the week. So study hard. Your assignment's in. It's the case of Shaw versus Reno from last time around. So your assignment is there. And we will see you. Good luck on the quiz. Good luck on the test. We'll have another PowerPoint explanation, narrated lecture coming up starting next week. See you later.